Apologize for missing Rachel.
It's okay, back on the record. Are you ready to proceed?
People are ready to proceed, Your Honor.
Yes, sir. We are. I believe we are ready to proceed. I didn't know if the people were. I think we're ready to move forward from questioning here.
Yeah, people are.
Correct, you're still questioning the witness.
Yes, Your Honor. All right, so trying to get back into the swing of things here. After, let's see, after the trying to go in timeline. After the joint, after the balcony, there came a point where you, Paige, and my client ended up in a hallway. Is that right?
Yeah, after I tried to close them out of the door, they both rushed back in.
And Paige lives with you. Is that right?
Yeah.
So she has a right to be in that house too, correct?
Yes, of course.
All right. You're also trying to lock Paige out as well?
The statement was they were leaving.
Now, when we're talking hallway, this is still inside your apartment, is that right?
Yeah, so if you can picture like a doorway,
Okay.
like if you're 1 foot in, 1 foot out, it's kind of like right there. You
Okay.
get what I'm saying? That's kind of where everything transpired.
I think there's the doorway is actually to the outside, right?
Yeah.
There's not like a shared hallway.
Yeah, like I said, it's a townhouse, so it's outside. It's like a porch, a cement porch.
And the tussling that occurred, it was Paige and Ms. Williams, you're saying, who were fighting you, is that
Yeah,
right?
they so
Is that correct?
yes.
Okay. And did this occur like inside the apartment?
Yes.
Okay.
This happened after I tried to you could say close the door.
Objection, non-responsive.
Objection sustained.
And there came a point you're indicating where Paige had you by the hair, correct?
Yeah.
And that's when you're saying that my client went into the kitchen, is that correct?
Yes.
And you're saying that my client grabbed a knife at that point, correct?
Yes.
If you know, the nurse, Ms. Amabo, she was in the apartment during the scuffle, is that correct?
Yes.
And if she said that you were the only person to grab a knife, she would be lying, is what you're saying. Is that right?
Yes.
Okay. The woman who has no animosity towards you, right?
Yes.
Okay.
I'm sorry, you said if she said what?
If she said that he was the only one to grab a knife,
Oh.
she would be lying, right?
Oh.
Sorry, thank you, Your Honor.
Can I make a statement?
You can only answer questions.
Okay.
In reality, you never put that other knife in the car, correct? Is that true?
You asked that question, yeah.
Sure. In truth,
Mhm.
you did not place that knife in the vehicle. Is that correct?
I placed the knife in the vehicle.
And in reality, you actually had the knife when you went after Paige and Ms. Williams, correct?
Not correct.
And during the tussling, they got the knife out of your hands. Isn't that right?
No.
And during the tussling is when you were stabbed in the arm, correct?
No.
And you were stabbed in the arm once. Is that right?
Yes, sir.
And then the fight stopped, correct?
No, sir.
You were not stabbed again, correct?
I was stabbed once. No, sir.
Okay. And then, according to your statement on direct, you then made threats towards, what was it, Paige?
I'm not sure.
Well, you made threats towards the two women.
After I was stabbed, yes, I made
Okay.
threats. Towards Mackenzie.
Okay. Thank you, Your Honor. I have no further questions.
Let me read it.
One moment, Your Honor. Just a few questions, Your Honor. Can you please further describe this tussle in the hallway that you and Mr. Meeks were talking about?
Yes, I can. So after I guess pushed her off the porch after I asked them to leave multiple times. They came back and busted the door, both of them, her, Mackenzie, Williams, and Page.
Can I ask, where were you when they busted back into the
I
door?
was inside the home.
Where at inside the home?
Kind of trying to lock the door.
Okay.
So,
Okay.
so after that happened, I kind of let them in.
What is it? I have to stop him. What does it mean, kind of trying to lock the door? What does that mean?
So they were like pushing against the door, and so like I wasn't able to lock it. So after like I wasn't able to close it all the way, I just let go of the door.
They hadn't actually left it.
No,
Okay,
they came back. They were supposed to be leaving, and they came back.
but you never was able to close the door and lock the door?
No,
So then they never left,
no, they never left. They never left the vicinity or the
or
premises.
the door, if you couldn't close it and lock it? Correct?
No, they left out, and as I was closing it, that's when they turned around and tried to bum rush back in.
Okay.
So
Can you
no,
explain to the court what bum rush means?
kind of run back towards the door as I'm trying to close it.
Okay. Did they actually run back to the door, or
Yeah.
were they at the door the whole entire time?
No, they were not at the door the whole time.
Thank you, Your Honor. So can you continue with the tussle in the hallway? How that
Yes,
happened?
so, like I was saying, as they, bum rushed the door, that's when, Mackenzie and Paige kind of attacked me, by grabbing my hair and pulling me down, trying to wrestle me. And at that point, I was just trying to protect myself and grab my hair so they didn't pull any of my hair out. And
Okay. And
Paige-
this is happened in the hallway?
yeah, this is
Okay.
like right in the hallway, doorway, kind of.
Oh, okay.
Yeah, so it's like right there. The door was open still. So that's why I kind of say like in the doorway.
And when you did have a knife, did you threaten anybody with
No.
it? No further questions?
I just need to follow up because I'm not 100% clear on the timeline, sir. So you're in the kitchen. The defendant and her sister arrive. You asked for the defendant to leave because you weren't comfortable.
Yes.
And then there was a time in which you were both exchanging words, I guess. When did we get to the porch?
We get to the porch. We get to the porch when I grab the weed out of her hand and I open the door to throw it out.
Okay, so you're not in the kitchen anymore.
No.
So you were washing dishes. Tell me how far the kitchen is from the front door.
It's like if this is the kitchen, this is the dishes and the sink. The front door is like right here and right there. So it's like
What's right here and right there mean? I don't know.
right in front of me, like right side next to me. There's a hallway, you know how there's a wall, there's
Okay.
a wall, and that's the hallway, and the front door is right there.
Okay.
So it's kind of like if this is the sink area, I would walk this way, and then I would walk that way. You get what I'm saying?
Okay, so you left the area where you were washing the dishes and went to where the door was, or had the defendant come into the kitchen?
No, she did not come into the kitchen. She actually went to the bathroom.
Okay, and so you went to the car first? Is that when you went to?
Yes, this is, I went to the car when me and Paige were having a conversation.
Okay.
The defendant was not involved in this conversation.
So when you had the situation where you threatened to slice the tires, that was not
That
between
that
you?
had nothing to do with
It was
her.
between you
That
and
was
Paige?
between me and my child's mother. Yes.
Okay, so that happened and then you came back to the house?
No, I
Inside-
never left the house. Oh,
Okay.
yes, I did come back in the house
Inside the
when I
house.
went and put the knife in the car. Yes, I came back inside.
Okay, so you came back inside and then is this the time where the defendant is smoking, a joint or?
No, she was not smoking. But
Oh.
she was rolling it.
Okay, she was rolling a joint when you came back?
Yes,
Okay, but your front door is still open?
yes,
Okay, and so that's when you took the joint and
yes.
threw it
and I
out?
threw it out.
Okay, got it. And
And
then,
that's when she assaulted me and punched me.
okay, and then you,
And then me and Paige are.
I didn't ask the question
I'm sorry.
yet.
I'm sorry.
And then you, I recognize that there's gonna be altercation or some words or something exchange between you and the mother of your child.
Yes.
But so after that, do you all end up at the front porch?
No, we don't.
Like, I'm trying to get to when do we get to the porch where
We
you
do not
pushed
end
her?
up at the front porch. We end up at the front porch when after she punched me in the mouth and me and my baby mama was having a verbal disagreement. I continuously asked them to leave. And so it's kind of like I'm guiding them towards the front door, like just go. So it doesn't,
How do you guide them to the front door?
I mean, like let's leave. Like you said you were leaving. They had everything they needed because she stated that she just needed clothes for the kids. So I'm
Okay.
like, if you got that, Mackenzie does not need to be here. You understand? So you guys can just go, or you can ask her to leave.
Okay, so they're walking towards the door as you're guiding them to the door, and then you pushed Mackenzie off the porch then?
No, that's not how that happened.
I'm trying to figure out when that happened.
Okay, so as I'm guiding them towards the door, they're like, she's like, they didn't want to leave. They were going back and forth. Mackenzie was mad because I took her weed and whatnot. And so as they were standing on the porch, yes, I did, go push her off the porch. And that's when they came back, bum rushed through the door as I tried to close it.
Okay, so your front door, you're inside the house. How far is the porch from the
The
front
porch
door?
is right there. It's just a little cement block porch with like a step.
One step down?
Yeah, just
Okay.
one step. So it's
Okay.
a little porch.
Okay, so they were technically outside the door at the time then?
Technically, yes.
Okay, and then you pushed Mackenzie off the stair,
Yeah, to close the door, yes.
and so that you can close the door?
Yes.
And that's when they start pushing back
Yes,
to
and
come
that's
in?
when they both kind
Got
of
it.
came towards the door.
Got it, so they didn't leave, you pushed them out the door?
No, I didn't.
That's what you just said?
No, I did not push them out the door. I did push Mackenzie out the door, yes.
Thank you. Redirect.
No more questions for this witness. at
Any
this time,
class
right?
based on my question?
Just based on those, the first questions there. Okay. So you threatened to slash Paige's tires, is that right?
It's their mother's car, yes.
Okay. Was her mother there?
No,
So Paige drove that car.
I would assume her or
Okay.
Mackenzie.
And you said that you want her to leave because she just needed clothes for the kids, right?
No, I did not.
I think you said that you were trying to push them out of the.
Yeah, she stated when she got there, and I stated that I was uncomfortable. She said, "Oh, I'm just here for clothes for the kids."
Okay. And when you pushed Mackenzie at the front porch, the children were still inside the house, right?
Yes.
She gathered clothes for the kids?
Did who gather clothes for the
Did
kids?
Paige gather clothes for the kids?
I would assume so.
The kids that are still in the house?
No, we have 4 children. So 2 oldest are girls, and they needed clothes for school.
Oh. Okay, no further questions.
Any redirect?
Briefly, Your Honor, one question. So how much time elapsed from when you had hands on Mackenzie to when you were stabbed in your arm?
after I pushed her off the porch, I didn't physically assault or touch anyone other than me having my hair.
Okay, and so how much time elapsed from you pushing Mackenzie off of the porch to when Mackenzie stabs you in the arm?
I'm sorry, I'm just gonna check. I think this is outside the scope of what my cross was. I didn't go anything beyond or anything into the stab.
We did not discuss this guy.
Okay, Your Honor.
Thank you.
Yeah.
Any other questions?
None, Your Honor.
Okay. May this witness be excused?
Yes.
Okay, you can be excused, sir. Thank you.
Thank you.
Any other witnesses today?
None, Your Honor.
Is the defense calling witnesses?
They're not at this time, thank you.
You can proceed. You need
That's
to-
it.
Well, we're on that way, sir.
Thank you.
Thank you. You can proceed to argument.
Thank you, Your Honor. Today, the defendant, Mackenzie Williams, is being charged with assault with intent to do great bodily harm less than murder. The elements of this charge include, first include that the defendant tried to physically injure the victim. Malcolm Wilder, I misspoke earlier, I said Malcolm Davis. I'm not sure why I had that wrong. Tried to physically injure Malcolm Wilder. As Malcolm testified, he was stabbed by the defendant at the time. And then the second element is that at the time of the assault, the defendant had the ability to cause the injury, or at least believed she had the ability, which is apparent by the stab wound. And then the third element is that the defendant intended to cause great bodily harm. Usually, if you're going to stab somebody, the intent is to cause great bodily harm. The second count is assault with a dangerous weapon. The first element being that the defendant attempted to commit a battery on Mr. Wilder or did an act that would cause a reasonable person to fear, apprehend immediate battery, the battery being the stabbing. The second element being intending to injure, I guess very similarly, you don't stab somebody without the intent to injure them. The third element being that the defendant had the ability to do so. Again, that's apparent by the completion of the stabbing. The fourth element of this charge being that the assault was committed with a dangerous weapon, or a dangerous weapon being a knife retrieved from the kitchen. Additionally, a lot of the questions, there are some questions of fact here that would be up for the jury. But at this point, the people do believe they've established probable cause to have both of these charges bound over to circuit court. Additionally, this is the victim's house where all of this is taking place. And the victim does admit to everything that he could have done wrong in this case. So at this point, the people would like to motion to have both of these charges bound over to the circuit court. Thank you.
Thank you.
I know I've been practicing for 13, 14 years. I've had a lot of cases with the prosecutor's office, the city of Lansing, and done a lot of assault cases. And I can't even count anymore how many times I've had to sit through the prosecutor's expert witnesses who get up and talk about the wheel of power and control. And I think it's pretty amazing in this instance, we've got a man who has no problem threatening the mother of his children to slash her tires openly in court, and he seems perfectly fine with that. He has no problem pushing a woman from behind, trying to kick him out of his house, despite the fact that Paige lives there. She has every right to be there as well. So we are seeing this wonderful dynamic of him trying to control Paige's life, not liking my client very clearly, and having this open and hostile animosity towards her because my estimation of where things are going, because he doesn't like it, is not being listened to. I'm bringing this up, Your Honor, because this court does have an obligation to look at credibility, and that is something the court can assess in this situation. Now, in determining credibility here, the people are trying to indicate, one, that there is great bodily harm less than murder. Count 1, they are alleging she had the intent to do great bodily harm less than murder. Count 2 says that she did make an assault upon Mr. Davis, and the name is actually correctly stated as Davis in the complaint, that she did intend to make an assault with a dangerous weapon, but without intending to commit the crime of murder and without the intent to commit or inflict great bodily harm less than the crime of murder. They are charging my client with mutually exclusive charges in this incident, and they somehow have the audacity to sit up here, make a straight face to this court and say, oh, no, he did both. She both intended to murder and she intended not to murder. All for this individual who got up and admitted to crimes on the record, Your Honor. There was one allegation of a stab from a gentleman who has no problem dealing in the role of power and control. If anyone here showed restraint, Your Honor, I think it would be the individual who stopped the tussle from happening by having to stab someone, perhaps, and then stop. Stop the fighting, stop the threat. Flash once, it stops. And he admitted to stopping, except for him being the person to continuously make threats afterwards. He has routinely showed that he is a person who is going to threaten people, who is going to put hands on people, and that has no respect, Your Honor. I believe for the court here, I do not believe that he is being honest here. Now, granted, that's my belief, Your Honor, but Your Honor, I would ask that this court dismiss charges in both counts here as the people have not met their burden. Failing that, Your Honor, I would ask that the people, or I'm sorry, I would ask that the court dismiss count 1 for the rule of lenity here, Your Honor, being that count 2, the lesser charge, and the fact that we've got 2 mutually exclusive charges here, Your Honor. I'd ask the court at least dismiss count 1 if the court feels that there is at least probable cause for one of these charges. Thank you, Your Honor.
Yes, Your Honor. First, I would like to acknowledge that there is case law that supports us charging both of these charges. Assault with intent to do great bodily harm less than murder, as well as assault with a dangerous weapon. People v. McEwen says that we can charge both of these. Additionally,
We charge both of these under what circumstances?
So
And is there a pin site?
let's see. There's insight on this. It's the GBH statutes. Yeah, there's no pin site on this. Yeah, the GBH statute says this section does not prohibit a person from being charged with, convicted of, or punished for any other violation of law arising out of the same conduct as the violation of this section. Felonious assault constitutes any other violation of law arising out of the same conduct as that which led to the great bodily harm conviction.
Give me the citation on that again.
It's people being McEwen. I don't have like the Westlaw citation up in front of me. It's Joel's working on it, but it's
Okay.
MCKEWEN.
W. Okay.
MC.
KEWEN.
Yes. Further, the charges don't require that there actually is injury here. However, we do have injury here, an injury that was so grave that the victim needed to undergo surgery to have a vein repaired and still doesn't have full function of his right arm. I believe he's right-handed as well, so it has been a huge.
I don't know. He didn't testify to any of that. He didn't
I think he
testify
did, Your Honor.
to being right-handed.
I don't know if he did.
He
So
did.
that part, I apologize.
Your Honor, regarding people being McEwen, Is it 326 Mitch Ave? 342, it looks like there's a red flag with a with negative treatment.
Uh-oh.
The pin site I have, Your Honor, is 326 Mitch Ave,
That's what I have.
342, and I've got it that on December 26, 2024, it seems like we've got some negative treatment. The first in part.
That's if that's the correct case, I have the same case pulled up, but I'm gonna let you continue with your argument and then I'll review the case.
That's all, Your Honor. I just wanted to bring that case to your attention, as far as charging both of these simultaneously.
Thank you. Do we have the correct citation on that?
Your
Oh,
Honor,
okay.
I'm pulling it up. Just give me a
Sounds good.
moment. I'll have it
No
for
worries,
you.
take your time, because I'm gonna read this while you do it.
I don't have Westlaw yet.
Your Honor,
Yes.
so what I've been able to find is it doesn't have a citation yet. It's a fairly new case. It says it was decided or issued December 26th of 2024. I do have a docket number, which is probably the best way to look it up at this point,
Thank you.
which is 158869. It's a Michigan Supreme Court case.
Here, I'll do one better. 2024 WL 5229735. If the court has the Westlaw insight, that's what I'm looking at right now. Mr. Martinez is correct.
You need additional time to review it.
I can make an argument, Your Honor. I think I'm ready for that. Okay. Your Honor, I do believe that McEwen is distinct from the case at hand here. McEwen was discussing the mutual exclusive, not the mutually exclusive doctrine as it regards to a court finding it mutually exclusive, rather the inconsistent arguments. In that premise, it's the same where a jury can find a person not guilty for a felony, but guilty for a felony firearm, being that those are the only two charges. So even though if there was a bench trial, the court could not find the defendant guilty of felon in possession, or I'm sorry, could not find a person not guilty of felon in possession, but then guilty of felony firearm. In that situation, Your Honor, yes, the jury can have inconsistent statements here, Your Honor. The challenge in the case was to the jury's verdict. I think that's different here. I would point to the dissent, which I believe makes the proper arguments here, Your Honor, and that is more applicable to the case, which it talks to exactly what we're saying here, Your Honor, that if the assault GBH statute requires the defendant to commit an offense with intent to do great bodily harm. The statute, contrarily to the felonious assault statute, expressly excludes that intent through the following language: without intending to commit murder or to inflict great bodily harm. As a purely textual matter, then, the language of the offenses is inconsistent, leading to the natural conclusion that the same person cannot be punished under both offenses for the same conduct. And Your Honor, I believe that that's what goes to the heart here. I believe that it is distinguishable in complete fairness. I know the court is just getting this right now. And it is a relatively new case, which I appreciate the prosecutor bringing to light at this time, Your Honor. But I would still say that McEwen is distinct from this matter, Your Honor. That the people really are talking out of both sides of their mouths at this point to say that she both acted with that intent and then without that intent.
Thank you.
Briefly, Your Honor, I would just like to draw attention that Mr. Milks is attempting to apply the dissent's argument here in this case, and that's not what we follow. I don't want to be too repetitive, but just the language from People v. McEwen that would apply here is that the GBH statute says that the section doesn't prohibit a person from being charged with, convicted of, or punished for any other violation of law arising out of the same conduct. So
I recognize that, but we can't ignore the fact that one element clearly requires there to be intent to do great bodily harm, while the other one says it's without intent to do great bodily harm. It's either one or the other. But I understand the argument that is being made. I understand both sides. In this particular case, I tend to agree with Mr. Milks that we can't have it both ways. The purpose of today, ma'am, is for the court to determine whether or not there's sufficient probable cause that the felonies charged were committed and sufficient probable cause to charge you as the person who committed the felonies. This is not a trial. We do not need to assess the facts to find beyond a reasonable doubt. That's a burden that's left for a jury trial if this is to make it to trial. And then the court also is the sole determiner of credibility of any witnesses, and the court also is charged with measuring whether the evidence raises reasonable doubt about your guilt. And I had testimony today from a Malcolm Davis. He testified that on or about March 21st, 2025, at their area of 445 East Edgewood Boulevard, Apartment A, that he was home in a home that he testified to that he shared with the mother of his children, a person identified as Paige, and that he was washing dishes when his child's mother came to the home. and entered shortly thereafter was the person he identified as Mackenzie Williams, the defendant, who is the sister of Paige, and that the Mr. Davis testified that he was uncomfortable with the Miss Williams being in the property because of some past accusations made against him, that there was some level of a verbal altercation that ensued between him and the mother of his child, at which point there was a threat to slash the tires of someone's vehicle who's not even there. And a knife, I guess, was presented and brought out to the vehicle, but then left in the vehicle as the idea of slicing the tires was abandoned. I had the same thought process that the witness had when he said that he left the knife there, because in my head, if you want them to leave, how are you slicing the tires? It doesn't make any sense. But it sounds like people are acting out of emotions and not processing with clear thought processes, is what it sounds like. But he said he placed the knife on the passenger seat of the vehicle. At some point, he returns inside the unit, and he did testify that Mackenzie had gone to use the restroom. She must be out of the restroom at this point, and she's rolling a blunt, some weed, and he takes the weed or grabs the weed out of her hand and throws it out the door. There sounds like there is another verbal altercation that ensues, and he testified that the mother of his child got in the middle of the altercation. And he also testified that I noted that Paige, the mother of his child, was holding him by the hair. In his words, she was attempting to protect her sister. And so the court found that as striking, because why would Paige feel the need to protect the sister if he was not being the aggressor? The court also believes that he was the aggressor because he's already introduced a weapon into a situation that involves zero weapons or zero threats. It's based on his own testimony. So they appear to the house that Paige lives at. She can come there wherever she wants, and she can welcome whoever she wants into her home. And I'm sure she is free to welcome her sister, or should be free. However, there's a threat to slice tires. Then because things are not going his way, he snatches something out of Miss Williams' hand, which is unequivocal. That's an assault. You don't get to snatch something out of someone's hand. That's an assault. Spitting on someone is an assault. And he only references assault when it comes to what the reaction was. But the assaultive action that initiated this interaction was prompted by him. He made the first assault. Why the prosecution would like to turn a blind eye to that is not for me to determine. Then we move forward to some tussling that takes place. And that he said he guides them to the door. I asked him specifically, what do you mean guide them to the door? Like, do they not know where the door is? When I asked him to describe how far things are, he says they're right there. So it sounds like it's a relatively small apartment, but he has to guide them to the door, including guiding someone who pays rent there or who lives there, a lawful leaseholder there, to the door. He wants me to believe, based on his testimony, that they left and that when he closed the door, they bum rushed. And I'm from the hood. I'm very familiar with what bum rushed is, but I wanted him to put it on the record for those who are not familiar. They bum rushed the door to try to get back in. And this is after he testifies, after I get clarification, that he pushed Paige off the stairs so that he can close the door and lock it. Again, he assaulted Paige. He assaulted Mackenzie, pushed Mackenzie, that is, off the stairs. Why the prosecution again? We've got 3 aggressive and violent actions by an alleged victim, and the prosecution doesn't hear any of those things. But they only hear the reaction that comes in after the fact. I had issues with the credibility of this witness when it came to discussing the tussle that took place, and how the knife was introduced, and that during this tussle, after he allegedly pushes someone, that they ran around him to go in the kitchen now to get a knife. How? Doesn't make any sense. Not adding up. There's no possible way he's blocking the door after he guided them to the door. That Mackenzie dodged, bobbed, and weaved, skirted around him, made it to the kitchen now to get a knife, while he is still making his way to guide them out the door, so that she can then stab him. There's something else that took place that there could not have possibly have been 2 kitchen knives. Something is missing. The story is not adding up, and he pushed her and Paige out the door to try to lock it. That's why he could not lock the door. That's why when he makes statements such as, well, I was kind of locking the door. What does that mean? Kind of locking the door. You either lock it or you don't. He was unable to lock the door because they were not yet leaving the home. And Paige doesn't have to leave the home because she lives there. But because he wanted them gone, he tried to push them out the door and close the door in their face. So I have grave credibility issues. I don't know why Paige is not here. Maybe she's like, I'm not getting into this anymore. Would be nice to have heard from her, to hear from somebody else. It would be nice to have heard from whoever this other person, the nurse that was there, to see, what is missing. But what I know is missing, and what doesn't make sense, is that they're at the door leaving with no knife. Then all of a sudden he's stabbed. So I believe that the people have failed to meet their burden as to how the knife got introduced into this. We're at the doorway and I pushed them out the door. So for those reasons, the case is dismissed.
Thank you, Your Honor.
Thank you. Okay, on the record, Mr. Milks, I'm gonna have to borrow you to represent Mr. Allen real quick as I arraign him on something. On the record, in the matter of the state of Michigan, I'm sorry, city of Lansing versus Tydonis Allen, 25-00799. Does he have failure to pay? Warrants. Appearance for the record, please. You can have a seat, ma'am. I have to give you a dismissal.
Good morning, Your Honor. Stephen Mills on behalf of my client, Mr. Allen.
Show cause for the
He, not for this one, no, he just,
I know I signed something.
this one was a pre-trial that he definitely cared for.
No, I'm talking about he had some other files that he failed to pay on, because I remember signing the warrant.
It's not warranted right now. He has a show cause scheduled for in June.
Okay, sounds good. Okay, this is a trespasser that it looks like you failed to appear for arraignment on. And the allegations that are on about February 27, 2025 at 6:21 p.m. You were at the area at or near 420 South Grand Ave, at or near Lenawee Street, city of Lansing, Ingham County, and that you trespassed on the property of another. So that is a misdemeanor. You do have the right to be represented by an attorney, and you have the right to take this matter to trial. You have the right to jury trial. You're presumed innocent until proven guilty. You have the right to require the city prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to be represented by an attorney. If you can't afford one, you can make a request today to have the public defender's office appointed to represent you. We have essentially forced Mr. Mills to stay here because he was already here. He is from the Office of the Public Defender, so that you can have representation for the purposes of this arraignment. And if you'd like to do an intake, I'm sure he's happy to do that at the conclusion of this arraignment, okay?
Okay.
Are you going to be making a request for a public defender on this?
Well, first you said the public defender.
Do you want an attorney, oh, you do? Do you want an attorney to represent you for this case?
Right now?
Yeah, and continuing forward, because I don't accept
Yeah.
pleas, so you're gonna have to get an attorney or represent yourself.
Yeah.
Okay, so I'll note that you are gonna receive representation by the Office of the Public Defender. The court will enter a plea of not guilty, but you do have the right to plead guilty, not guilty, or stand mute. But you probably need to get some discovery or evidence before you decide whether or not you're going to be pleading guilty, and get advice of counsel. And so this will be set for pre-trial before me, and it's going to be on May 20th at 11 a.m. Okay, the bond on this matter will be set at 100 personal recognizance for the pendency of this matter. You're not to be at the area of 420 South Grand, what is it, CATA? I'm assuming,
Yes.
okay, the CATA station. You're not to be at that area because they're saying that you're not allowed to be there. So until that's flushed out, you should stay away from the CATA station to avoid any further charges. Do you have any questions at this time?
Yes, I do.
What's your question?
I saw you say,
You never saw me. This is the first time you've ever been here on this case. You saw me on some other cases that you owe money on.
I could have swore when I came down here, when I got out of jail, because I did go to jail, and they got put from privacy the next day.
Okay,
When I did have a court date, I came and I standing here with a, yeah, if I play guilty to the, our law that they would drop the trespass. And that's
Yeah,
all.
no,
But
no.
he gave me 2 copies.
Yeah, Your Honor. I think I see the discrepancy.
they are the same date of action.
He's got a 25,659 OM, which it looks like that one has been closed and he owes money on, I would guess.
Could
And
someone
the,
pull that file for me?
and the new one is what the court has just arranged him on. So
Yeah, but
ours new.
he believes that there was a plea deal. So we'll
I see
see.
exactly what the court said.
number.
25-00659 that he owes money on.
The entry date on that I had it February 28th. The new charge is 317. I see what he's saying. All right.
Yeah, he said he believed that the offer was if he pled guilty to one, they would dismiss the other. I don't know. I'll see what my file says.
659, says case closed.
No, I need you to go get the file for me. Hold up, here. How in the possible world is this happening? Let's see here. Well, same date of incident, 2/27/2025. Same address, 420 South Grand. Same officer, Jamil Jones. He's already pled guilty to this trespass. I don't have a clue what's going on here. Because I have here in file number 25-00659, he had trespass and hinder, obstruct, and oppose. Offer, plead guilty to trespass, dismiss the H&O. Get a city attorney upstairs, please.
Should I have them sit behind me? please?
Yes,
Oh,
please.
Thank you.
Are you coming back for the 130s?
Matt is gonna. do
Oh,
the
and Mr. Nagel
finishing
will
up,
do those.
yeah.
Got it.
So I don't believe so. I believe it'll be
Sounds
for our jury trial on Monday.
Oh, we have a jury trial.
It's the trial that's tried to go like twice now.
Sure.
John Kelly, the one, aren't they like?
Their
uncles or-
nephew.
Oh, uncle and nephew, got it. Well, we've been having a lot of jury trials in this building, so it's our turn.
Should not be. It should be one day, Your Honor.
I don't know, that's what I'm sure they thought, and then day two came. I wanna know how we have a citation and then an affidavit, all this. Well, you know what probably happened? Was this on a weekend? It was February 27th. Thursday. Yeah, the only thing I could consider it is that the 28th is when, a Friday?
Yeah.
No, it's messy work, that's all it is. I can't consider what it is. This is no call it, city attorney.
Yeah, I think she was down here.
They probably didn't answer the phone. It's probably wrong.
130 is all that the four
It's the
four
four
co-defendants,
co-defendants,
right?
correct.
Okay, yeah. Then I don't believe I'll be here. I believe that will be Matt Nickel on those.
Look at this guy.
Hi, Mr.
Your
Vinker.
Honor, accept me, passing the bar here without a coat and tie on.
I'll
Well,
accept.
I asked, you have it brought up, so I get it.
What we talking about?
Mr. Allen has so I was just arraigning him on this when he said this was a part of another plea deal. So I pulled the other file and he did plead guilty to trespass, dismiss H&O on the 25th. And he said, I saw you in this. I said, no, this is the first time I saw you in this. So this, yeah, but when you look at the citation,
Okay.
it's for the same exact date at the same exact address, same exact officer. So one has the citation, the other one has a complaint in warrant for the trespass.
It was offensive.
Oh, and book that process.
Right, and he was arrested, so we know he was arrested for the trespass.
Hang on a sec. Can I see your files, please?
This is the one I was going to arraign him on, and then this is the one that he had.
That is already closed.